So I'm going to try and cover 3 topics, which is a lot to cover, and I only have 15 minutes. Apparently my colleagues need some time to talk too. So this is going to be a fairly high-level whirlwind overview. We'll have some time for questions at the end, and I will also hang around afterwards if you have more specific questions. This is mostly just going to be a very broad, very quick litigation update on a number of topics. So first topic I'm going to cover is parental rights. So when we talk about parental rights, the main context that this comes up is secret gender transition policies in school districts. So I'm going to assume most of you are familiar with this at this point. We've talked about it a lot. But a lot of school districts in the country have policies that allow minor students of any age to change their gender identity at school, their name, their pronouns, their bathroom use, often without parental notice or consent. And there have been numerous lawsuits against these policies on a parental rights theory, that this violates parents' constitutional rights. So by my count, there are now about 35 of these cases around the country. We have brought 3 of them. So I'm just going to sort of give you an update on where this litigation stands currently. So there have been a number of wins already. The 2 most significant would be our case, actually against the Kettle Moraine School District. And then there's a case out of the Southern District of California, of all places, that it's still ongoing. But they want a motion to dismiss, and it's sort of pretty clear they're going to win in the long term. And then there's been multiple cases that have settled with a fairly significant payment to the plaintiffs. There haven't been as many wins as I would hope so far, and there have been some losses, probably more losses than wins. And a few of the losses have been on the merits, but I would say most of the losses have actually been on ancillary issues. So even though there's been more losses than wins, it hasn't been courts saying, this is totally fine, you can hide gender transitions from parents. In the main, it's been other issues, sort of kicking the cases on other grounds. I don't have time to go into sort of all the different ways that cases are losing, but I just wanted to sort of put a few up here and explain that there are ancillary ways that the cases are losing. The silver lining of this is, even though some of these cases are losing on ancillary issues, various judges and courts are writing separate opinions commenting on the merits of these policies. And so there's this growing body of judges around the country, and here's a few quotes, I'm not going to read them, but there's now a growing body of judges around the country who are recognizing, I think, that these policies violate parental rights. In each of these cases, the sort of main decision from the court was not on the merits, and this was sort of a side commentary from one of the judges about these policies. So eventually, these cases are going to reach the United States Supreme Court, I think. In my opinion, it will eventually. But when and how soon? So only 2 of the cases so far have gotten to that level where they can ask review of the Supreme Court. The most recent one was actually our case against the Eau Claire School District. And in the lower courts, we lost on standing, so it was not sort of the main merits issue. It was when parents can sue to challenge these policies. And the lower court said parents can't sue until the policy's been applied to their child. I think that was wrong, but that's what the lower court said. So we went up to the US Supreme Court, asked for review of that question, and we were just barely denied. We got 3 votes for a grant, so we were 1 vote short of a grant. Disappointing, but sometimes it takes multiple pitches to the US Supreme Court before they eventually take a case, and a vote against doesn't necessarily mean that they agreed with the lower court decision. It can be timing related or whatever. But the dissenting justices wrote a dissent, and they commented that this is a question of great and growing national importance. And though this was the second cert petition, it was the first one to get a dissent and to get votes for a grant. So all that is to say, I think it's only a matter of time before the court takes up one of these cases, and I think this is a signal that the court is interested in the future. So the cases that I'm watching that are the most significant ones, there's a case called Foote. This is out of the First Circuit. This is actually the only Court of Appeals case, I think, where the court held on the merits that one of these policies doesn't violate parental rights. Again, I think that's wrong, but the case is teed up pretty squarely, and so the next step is a cert petition to the US Supreme Court. I'm sure the parties are going to do that, and so that's a really important one to watch. And then the second one is out of Florida. It's called the Littlejohn case. This has gotten a lot of press. The plaintiffs didn't lose on the merits. It was more of a ancillary test called shocks the conscience, the idea that It's not enough to prove a parental rights violation. The plaintiffs have to establish that the actions were so egregious that it shocks the judicial conscience. It's split the 3 judges 3 different ways, and so they're currently asking the 11th Circuit to take the case en banc, which would be all of the judges in the 11th Circuit ruling on it. I think there's a decent chance they'll get it, and if they do, that's going to be a very significant case to watch. The bottom line for school districts is the safe thing to do, the obvious thing to do, is just require parental consent. So there's lots of lawsuits against school districts who don't. There's very few lawsuits in the other direction. So that's the safe thing to do. That's our recommendation. Corey is going to be talking about our model policies later, and we have model policies on this topic that you can look to. Okay, enough on that topic. So a related issue on parental rights is FERPA and the PPRA. So an early executive order from the Trump administration directed his administration to prioritize parental rights, and in particular, FERPA and PPRA enforcement. So what are these 2 laws? So FERPA is, as relevant here, it's a law that gives parents access to their children's education records, and the PPRA provides parental notice and opt-out for certain kinds of surveys and evaluations. School districts have to provide those rights before they give these surveys and evaluations. These laws have been in place for a long time, but they haven't been enforced as aggressively by the federal government. But the Trump administration has emphasized that this is going to be a priority. And why? So it goes back to these secret gender transition policies that I talked about. So a lot of these policies have a form to keep track of what name and pronouns we're going to use for the student. This is Milwaukee's. And I don't know if you can read this, but at the top it says confidential and keep this out of student records. This is a pretty blatant violation of FERPA in my view. And then some of the questions later in the form are questions that I think are covered by the PPRA and require parental notice and consent, and these districts are not providing that. So the Trump administration has already brought enforcement actions against California and Maine for FERPA violations because of gender support plan forms like this. We have filed a complaint against the Milwaukee Public Schools. We're sort of waiting for the administration to decide what it's going to do with that complaint. But the sort of bottom line for you all is don't hide student records from parents. That's pretty simple, number 1. But number 2, you should brush up on FERPA and the PPRA because the Trump administration has indicated that this is a priority for its administration. And then the last sort of parental rights issue I'll mention, this is a case you've probably heard about. It's currently pending before the Supreme Court. I only can cover it briefly. So this is a case out of Maryland. The school district adopted a curriculum of LGBT-themed books that it would read to students from pre-K on up. Lots of parents objected on religious grounds, and the school district basically said, we're not going to allow opt-outs of any kind. So this is not a parental rights claim directly, it's primarily a religious liberty claim, but obviously they're deeply intertwined, and so I would expect the court's going to say something about parental rights in the decision. The oral argument, it's always hard to read the tea leaves from the oral argument, but it seems very likely that the parents are going to win the case, but it's not clear how broad of a ruling it's going to be. So during the arguments, the justices were clearly wrestling with how far this opt-out right should go. So the decision's going to come out this summer. Read it carefully when it comes out because it'll be very important to opt-out rights. But I think the bottom line for you all is, again, the safe thing to do, respect parental rights, allow parents to opt out of curriculum that they object to. All right, switching topics entirely to sports. So on this topic, the sort of way that I frame the question here, this is a question a lot of districts ask, is can we separate our sports based on biological sex? And you would think it's a yes or no answer, but I'm going to teach you to think like a lawyer here. There's actually 3 different answers to this question. So the first answer is you may, but you're not legally required to. Sort of the second option is you must, right? And the third on the other side is you may not. Unfortunately, there are things that cut in all 3 directions currently. So let's start with the text of Title IX. I don't know if you can read that, but it says that school districts may operate sports and separate them based on sex. So you'd think that would be a clear answer, at least to ruling out the may not category, but there are some cases that have held that school districts may not separate sports based on biological sex and actually violates Title IX and equal protection. Now, I think those cases are wrong, and they don't cover Wisconsin, so you don't need to worry about them currently, but they are out there. On the other hand, the Trump administration has taken the position in an executive order that you must. And although the Title IX reg says may, there is separate language in Title IX that requires equal opportunities for sports. And so the idea is that allowing transgender students to participate in female sports actually takes away opportunities from women. So Trump has brought enforcement actions already against Maine most significantly, but a number of others. So these issues are being litigated around the country and ultimately will be resolved. The WIA, as you probably know, has changed its rules in response to this executive order. So the operative rule, I think, in Wisconsin is you should limit sports based on biological sex, but all of this is going to play out. Now, I think these two lawsuits, these two cases from the Fourth Circuit and the Ninth Circuit are unlikely to survive. Both of them have cert petitions pending to the US Supreme Court. They've actually been pending for a long time, since last fall, a lot longer than you would normally expect. And I think that's because there's a related case called Skirmetti. Don't have time to go into the details of that, but it's likely to affect the outcome of these cases. So I think the Supreme Court is holding these cases for that case, which is going to come out this summer, and then what it's going to do is GVR them, which is just sort of a fancy way of lawyers saying, hey, nice try, try again. So I think the court's going to send these cases back to the Fourth and Ninth Circuit. So I think they're going to be vacated. On the other hand, the Trump's position has been endorsed by the Second Circuit. There's sort of a case that's been all over the news about track in the Second Circuit. They lost initially, it went up to the Second Circuit, and the Second Circuit said, no, this is actually a viable Title IX theory. It may violate Title IX to allow transgender students to participate in female sports because it displaces women and their opportunities. So very unlikely that the may not is going to win, more likely that the must is going to win, but you're pretty safe in the middle with may. And so I think the bottom line for school districts, again, is limit sports based on biological sex. That's sort of the safe thing to do at the moment. So same question, same topic related to bathrooms. Can districts separate bathrooms based on biological sex? And again, you have these same three options here: may, must, may not. So in the middle category, again, we have the text of Title IX, which very explicitly says that schools may provide separate bathrooms based on biological sex. So again, you would think that would answer the question and rule out may not. But in the Seventh Circuit, there are two cases, and the Seventh Circuit is what covers Wisconsin. There are two cases where the Seventh Circuit has held that limiting bathrooms based on biological sex violates Title IX if you don't allow a transgender student to use the bathroom that they identify with. In the must category, an early Trump executive order said this, directed agencies to take appropriate action to ensure that intimate spaces are designed by sex and not identity. So obviously the Trump administration is interested in sort of pushing the view that schools must limit bathrooms based on biological sex, but it's a bit of a harder argument to make, and as far as I'm aware, the Trump administration has not yet brought enforcement actions against school districts on this theory, but it may be coming. So for the time being, the Seventh Circuit is the rule. If you do not allow transgender students to use the bathroom they identify with and you get sued, there's a decent chance you will lose based on these cases. But I think there's a very good chance that that case will get overruled eventually. It would have to be either by the Seventh Circuit as a whole or by the Supreme Court. And I think it will once it gets to that level, but it's not clear how long that's going to take or when that's going to happen. So there's kind of two ways that could happen. It could be directly overruled in a case, and there are 3 cases currently winding their way through the court system where that could happen. It could also happen indirectly. So some other related case from the United States Supreme Court says something that's relevant that undermines those prior cases. I actually think that has already happened in the litigation over Biden's Title IX rule. That's an argument that we're making in the Elkhorn case, so we'll see what the court said. But sort of the bottom line is, I think the holding is so clearly inconsistent with the text of Title IX that if it gets to SCOTUS, when it gets to SCOTUS, it's going to be overruled, but it's not clear when. So I'm going to stop there. We did a webinar on this issue. If you're interested in the bathroom issue in particular, we did a webinar on it earlier this spring. It's on our YouTube channel. I encourage you to look at it. We go into a lot more detail than I possibly could right now. But I'm happy to answer questions about any of these topics later.
All right, good morning. I'm Dan Lennington. I'm going to talk about, in 15 minutes, what Trump has done on race since January 20. I figure he has done probably 2 or 3 dozen major actions. Most of them affect local school districts because local school districts are a recipient of federal financial aid. Most of your budgets, 10 to 15%, comes directly or indirectly from the federal government, and so you're covered by all these rules which could affect you and lead to you having your money taken away from you. So that's why you want to listen to what's going on with Trump. What is Trump targeting? Trump is targeting diversity, equity, and inclusion. So just to get some background, a lot of people don't exactly know what that means or can't put a precise definition on it. But since the Biden administration, the federal government and the Department of Education has been targeted towards racial classifications, towards eliminating racial disparities, and using race-conscious methods to level the playing field among races. That's essentially what DEI is. This is a racial balancing of outcomes. And you'll hear schools use euphemisms, and maybe your staff members or your administrators will say things like, we're going to level the playing field. We're giving all the students all the resources they need. Sounds pretty good. We want to target underrepresented groups. Your alarm bell should go off if you hear that. We want to help disadvantaged or marginalized students. Alarm bells should be going off. We want to teach culturally relevant things or use restorative practices or social emotional supports. All these things, you should be grabbing your pocketbook and being worried about your taxpayers' money going out the door and you losing your federal funds. At the end of the day, DEI policies, they focus on racial groups rather than individual needs. Racial stereotypes abound, such as we need to help all black children because they are black children, rather than we need to help this student because this student needs help. That's essentially what DEI is. DEI trainings focus on things like anti-racism or systemic racism. They focus resources on certain racial groups over other racial groups. And based on the first 100 days of the Trump administration, it's very clear in my view that the new federal administration aims to upend all DEI-related practices. They've actually renamed DEI to discriminatory equity ideology. So what does this look like in your school district? These are some things we've found in other school districts that are clearly DEI and very troublesome. You should meet with your black students first and more often. That is a written policy in 2 different school districts we found and we've litigated over in Wisconsin. We've seen segregated parental meetings based on race, segregated parties. I've seen segregated bus rides. Teachers disaggregate data. They like to do that. They separate the races to determine whether they are particularly helping one group over another in their classroom. Extra supports for minority students, racial balancing, privilege walks, anti-whiteness training. Whenever you hear someone saying we need more diversity is better, we need to fix our racial disparities, those are all big warning signs that your district is going into DEI territory and going to get the wrong end of the Trump administration's enforcement. So what are the tools that the Trump administration is using? They're using 2 tools here. One is the case called Students for Fair Admission versus Harvard. This was the decision interpreting the Constitution and Title VI to explain what is race discrimination. That's really the question. What is unlawful race discrimination in America? The Supreme Court said 5 things. They gave us 5 tests. Schools can't use race for racial balancing, curing societal discrimination, or just plain old diversity. They can't use race for race's sake. Schools can't use broad and arbitrary categories like Asians or Hispanics, which the court said are arbitrary and illegal just by themselves because they are so overbroad and under-inclusive. Schools can never use race as a negative. Special services targeting one race over another. This program is for black students. Schools can never use race as a stereotype. One of the quotes from the case is that Harvard would say, black students can bring something to the classroom that others cannot. You will hear that all over Wisconsin. That statement alone is evidence of race discrimination. That is a racial stereotype. And race, if ever used, has to be a temporary remedy. The enforcement tool used of that legal theory is Title VI, which basically says if you take federal money, and all of you do, you cannot discriminate based on race as interpreted by the Students for Fair Admission case. If you do take federal money and you discriminate based on race, there's a process where the federal government can take that money away from you. They've already started that process and started to take money away from other school districts. We have a certain number of complaints that are pending right now. We haven't actually seen at the local level yet. We've seen schools like Harvard have been battling over this, and at state levels, but it is coming. The case in which a school district gets their federal money pulled is coming. It's just a matter of time. So what are some of the major executive actions? I can't go all through 30 or 32 of them, but I'll give you the high-level executive actions that President Trump has taken. One is he's ordered his agencies to to identify and terminate DEI grants, DEI programs, policies, anything related to that that's coming from the federal government to the states, then to local school districts. Cancel contracts, cancel grants. You've seen a lot of this going on in the news. A lot of it's in litigation right now. Some has been put on temporary holds. Number 2, investigate. He's ordered his Department of Education and Department of Justice to investigate schools that use DEI. That was on second day in office. He issued that executive order. Third, he issued an order to end indoctrination, is the phrase he used, and DEI training in K-12, and federal funds that are used for this training. So the Trump administration defines DEI as an ideology that treats individuals as members of preferred or disfavored groups rather than individuals, policies that minimize merit and capability in favor of generalizations, policies that teach that, or curriculum that teaches one race is inherently superior to another, one race is inherently racist, one race is automatically privileged, one race bears the responsibility for something bad that happened in the past. You should feel guilt because of your race. These are all evidence of the type of, quote, indoctrination that is in the executive order. Now, there's a lot of issues with this. Being overbroad, how do you define it? How do you cross the line? Are we impeding school teachers' ability to teach? Is it handcuffing them to teach about history? These are all issues that will eventually be sorted out, hopefully, but just letting you know, this is what the administration is targeting. They are looking for examples of this. School districts that do this will be subject to investigations where school districts will have to explain to OCR investigators what they're teaching and why they're teaching it. Discipline. Obama administration and Biden administration both emphasize racial disparities in discipline. Said if your school district is punishing more black kids than their representative portion of the population of your school, it's just, you probably are discriminating based on race. That has been the policy of the United States government since 2009, 2010. It has led schools to be very, very concerned about how many black kids they're punishing, how many Hispanic kids they're punishing versus white kids. And it has led to a lot of say unintended consequences in discipline in school. On April 24th, Trump administration has wiped that all away. There is a new race policy with regard to discipline, and it focuses on individuality and not membership in groups, not membership in racial groups. So those are 4 big executive orders that affect K-12 schools. So what has the Department of Education done? Number 1, in February, they issued a Dear Colleague letter on Students for Fair Admission. This is an important resource for you in your district. It explains what is race discrimination. It explains why DEI is race discrimination. And it describes what is the federal government's position and the U.S. Supreme Court's position on equal protection and race discrimination. If you, in your district or your school, are having pushback from administrators or teachers or principals or assistant principals about, well, we can't do this or we can't do that, this resource, this Dear Colleague letter, lays it out very well. And that is the position that is being enforced by the Trump administration. Number 2, they have put up this website called ndei.ed.gov. It is an invitation to parents to complain about your school district. And when these complaints come into the Department of Education, the OCR, they will be evaluated, and you might have investigators hopping around your school asking questions. So this is something to be aware of. I view it as a resource. If you're in a school district, you probably do not view it as a resource. But it is something that parents are using, and this is a way for them to submit complaints under Title VI for race discrimination. We do, at will, submit our own complaints and file them separately, but this is sort of a more informal portal for parents to fill out. The last thing the Department of Education has done is they required all superintendents of states to certify by April 24th that they are not discriminating based on race. Every state except for 15 states signed this letter. Certification. It literally says, I promise not to discriminate based on race as interpreted by the U.S. Supreme Court. Wisconsin did not sign that. Wisconsin refused to sign that and is now involved in litigation over whether this can be enforced or not. At the same time that the certification came out, the Department of Education sent an email to Jill Underly and said, by the way, if you don't want to certify, local school districts and schools, independent charters, they can certify if they just go to this website. Superintendent Underly did not tell the schools that in a timely manner and buried it in the middle of an email that was very hard to find. So we are here to tell you that if your school district would like to certify that you don't discriminate based on race, you can do this. We will help you certify that you're in compliance with federal law. And we think that would be a great idea. We are putting together a coalition letter that has a lot of school districts, a lot of the districts that are in this room and schools that are in this room are sending a letter to the Trump administration saying, hey, we are certifying, we promise we aren't discriminating based on race, even though our superintendent won't make that same promise. So if you'd like to sign that letter, we're still putting it together, and we have heard that in the litigation, it may actually be very valuable for the court to know that independent schools, school districts are actually certifying their own compliance over and above, even if the superintendent refuses. So, takeaway. If you use race, it has consequences. If you use race, I struggle to figure out a way you could use race in dealing with students, dealing with employees, hiring, promotion, training, benefits, priority, preferences, privileges, curriculum. I have trouble finding a way you could use race with regard to your relationship to your students or your staff that would not be very problematic and very concerning and could lead to losing federal funds. So you can use whatever phrase you want to use. You can say you want to be colorblind, you want to be race neutral, you want to be race blind. These are all fine. Just if you use race, that's just a big red flag in almost anything that you do. I'll take questions at the end. But that's it. Thanks.
Managed to make it down and back up without tripping, so far so good. All right, I'm Lucas Vebber, also one of the attorneys here at Will. I'm going to talk about kind of a grab bag of other legal cases and legal issues that are out there that may be interest to you as board members. So we're going to talk about the ongoing Act 10 litigation that's now in the Court of Appeals. We'll talk about the recent decision from the State Supreme Court on the governor's 400-year veto and how that impacts revenue limits going forward. And then we've got the Milwaukee SRO case, which is a case that we brought that I just want to touch on briefly, and then some related litigation statewide. And then I'll close with some updates on public records. So begin with Act 10. The Act 10 is probably one of the most litigated pieces of legislation, certainly in state history over the past decade. Almost immediately after it was adopted in 2011, it was challenged in both state and federal court. In federal court, it was challenged under equal protection grounds. They said that the law, insofar as it divides between public safety and general employees, violated the equal protection of those employees. That lawsuit went up to the Seventh Circuit, the United States Court of Appeals, which upheld the law on that challenge, brought into the U.S. Constitution. The state Supreme Court upheld Act 10 on a related challenge. They brought an equal protection challenge saying that the law discriminated between union and non-union employees. The state Supreme Court upheld the law of that challenge as well. A couple of years ago, some new litigants brought another challenge, the exact same challenge actually as the original federal challenge, but they brought it under the Wisconsin Constitution. So we have a state constitution, we have a federal constitution. They oftentimes the federal constitution can be viewed as kind of a floor. The state constitution protects all the same things, but it can protect more in certain cases. What they have argued here is that the state constitution's equal protection guarantee should be interpreted more broadly, and under the state constitution, they have said that Act 10 violates equal protection. They brought this case in Dane County Circuit Court. The defendants in that case and the legislature intervened. The defendants all moved to dismiss. The judge in Dane County denied that motion to dismiss, and when he denied the motion to dismiss, he also basically said, I'm denying this because Act 10 is unconstitutional. It was kind of an extraordinary decision from the judge. The parties then said, well, where do we go from here? The judge had them brief what's called judgment on the pleadings. I'm getting into the legal weeds that probably aren't of interest, but the parties then briefed that out, and in December of last year, the judge issued a decision effectively declaring Act 10 to be unconstitutional because it violated the equal protection provisions of the Wisconsin Constitution and striking various sections of the law. So that was kind of an interesting remedy. Courts don't typically strike provisions of acts, sections of an act. It creates all kinds of practical issues. Those statutes have been amended since then, for example. So by just striking provisions of Act 10, the act itself, rather than the underlying statute as it exists right now, it's really unclear what the law is even, because if you strike it then, you kind of went back to pre-Act 10 law. But again, those statutes have been amended a little bit since then. So it just created a lot of issues. One of the areas that it created issues as well is it restored what's called fair share payments for public employee unions. Those were declared unconstitutional, a violation of the First Amendment by the United States Supreme Court since Act 10 was adopted. So it basically restored Wisconsin law back to a pre-Act 10 state, which is now unconstitutional under the First Amendment. We represent a Kenosha school teacher in that. That case was appealed. It is currently in the 2nd District, which is where we are now, State Court of Appeals for the 2nd District. The plaintiffs in that case moved for what's called bypass. They tried to skip the Court of Appeals, get the case directly to the Supreme Court. The Supreme Court denied that petition. It is now in briefing at the Court of Appeals. So we filed our initial brief. The other side's brief is due a week from Monday. Once they file their brief, we'll then file a reply brief. It'll be fully briefed at that point, early June. It is possible, if not likely, that they will renew their motion to bypass again at that time and see what the Supreme Court does, and something to keep an eye on there. If it stays with the Court of Appeals, it's likely, I think the Court of Appeals' average time to decide a case can be over a year. So it's really up to the Court of Appeals as to how long and quickly they can get that out. The reason it takes so long is our Court of Appeals has mandatory appeals. They have to hear every appeal that's filed. and there's only 16 of the judges, so it takes them some time to kind of get through everything. They also could have oral argument on it. There's a lot of uncertainty there. But the couple of key takeaways are the underlying challenge in Act 10 is the exact same challenge that was brought previously and denied by the Seventh Circuit. They just rephrased it as a state constitutional challenge. So the real question is the Wisconsin Constitution going to be read differently than the federal Constitution? It never has, in this context, it never has before. Our court has actually explicitly said that our equal protection guarantee and our state constitution is coextensive. It's identical. It protects the same things that the federal Constitution protects. So it'll be a kind of extraordinary remedy if the court does go that route, but something to keep an eye on and something that would certainly impact budgeting and your day-to-day operations as board members. Next, I'll talk about the 400-year veto, and sorry, these are, didn't think they were going to be animated, so that's, but we're out here. Okay, so school districts in Wisconsin are subject to what's called a revenue limit. This is different than a levy limit. Oftentimes those terms are used interchangeably, but they're actually very different. As you probably all know, a revenue limit just limits the amount of total revenue that a government entity can get from all sources, so that if one source increases, other sources have to decrease. A levy limit is just a limit on the amount of property tax levy that can be imposed by a local unit of government. So school districts have revenue limits. As a result, when state aid increases, for example, property taxes go down, so the levy actually decreases. So what the legislature often does is they will appropriate state aid and then appropriate less of an increase in revenue limits, forcing property taxes down. It's kind of a common thing the legislature does over the years. In the past biennium, the legislature passed a budget which included an annual increase for 2 years in the revenue limit for school districts, and the governor used his veto pen. Governors in Wisconsin have a very powerful veto pen. To partially veto it, he kind of struck some digits from the years and ended up rewriting the law so it actually was not a 2-year increase, it was a 400-year increase. So every year for the next about 400 years, the revenue limit will go up by a certain amount. It was an interesting move by the governor, something that was challenged at the state Supreme Court. Just a couple of weeks ago, the state Supreme Court released an opinion upholding that veto. So that is the law here in the foreseeable future. The practical impact, of course, will probably be higher property taxes. It certainly increases revenue limit authority across the state. It's a change in state law, so ultimately I think it's likely that the legislature and probably not this governor, but a future governor would come to an agreement to repeal that, or at least change it in some way, and they could do that through regular legislation. And I also think it's going to have broad implications on how the legislature budgets and how they craft budgets going forward. I think the legislature, seeing what the Supreme Court did with the partial veto here, is very unlikely to put anything like that in a budget going forward to prevent governors from rewriting the laws that they put out there. They're going to be very careful, I think, as to how they do that. So something to keep an eye on there. The MPS SRO case is one that we brought in Milwaukee County Circuit Court. I just want to mention it very briefly. So as part of the sales tax legislation that gave Milwaukee a new sales tax a couple of years ago, there was a compromise struck, and they said, okay, we'll give you sales tax revenue, but we have to get school resource officers back in Milwaukee schools. The way that came in state law was a statutory requirement that the Milwaukee Board of School Directors get those officers back in by January 1st of 2024. They missed that deadline. Several months later, actually almost 9 months later, we brought a lawsuit on behalf of a Milwaukee taxpayer and a parent, an MPS parent, saying that they don't have discretion not to follow that law. They have to get them in. We asked for what's called a writ of mandamus. A writ of mandamus is a common law writ. It's most commonly associated with public records. So it just basically is used when a government official has a non-discretionary duty, something they have to do and they're not doing it. A writ of mandamus compels that government official to take those actions, basically commands them to do what the law requires them to do. We sought that here. Milwaukee County judge granted it. And the officers ultimately, after some back and forth and some delay, did get them back in schools. I just mentioned that here quick because I think it just kind of highlights that there are people who are engaged in this, and there are ways for the public at large to kind of compel school districts to act in accordance with state law. We see this in other areas. One area that we've seen it come up more recently and more often is in school buildings, and particularly vacant school buildings, and school districts that don't want to sell those school buildings, or they want to impose some kind of deed restriction on that sale as it goes to somebody else. I think that's an area where litigation is probably likely going forward, and whether school districts have the ability to keep those vacant school buildings or to impose those kind of restrictions on the sales is something that I would certainly keep an eye on going forward. And then I will wrap up today with public records information. So anybody who was here last year, we gave a kind of a quick overview of public records and a kind of a primer on that. There really hasn't been a lot of updates over the past year. We do have resources available on our website called the Citizen's Guide to Open Government, which really explain open meetings law and public records law. I'm kind of an outsider, a member of the public perspective, but maybe of value to you as a government official as well. But there really haven't been many updates to report on over the past year. A couple things I want to note. There is currently legislation to repeal what's called the Friends of Frame Park rule. So typically, if you bring a public records request and you ultimately get the records after, and you ultimately have to sue, and then you get the records after you sue, you were historically able to recover your attorney fees. As a result, a lot of attorneys would take these cases on contingency. It made it easier for members of the public to get lawyers because they didn't have to pay them directly. They could recover their fees at the back end. But there was this case from the state Supreme Court a couple of years ago called Friends of Frame Park, which said no, actually, unless there's a court order that orders them to release the records, you can't get your fees. So as a practical matter, what that has meant, or at least what the fear was that it would encourage government officials not to turn records over, because really someone would have to bring a lawsuit, and once they brought the lawsuit, as a government official, you could just turn the records over then. You wouldn't have to pay the attorney fees. Kind of call their bluff, I guess, on record requests. For our operations and our organization, it doesn't impact what we do because we don't bring lawsuits assuming we're going to get fees. We bring them for public records cases to make law in kind of extraordinary cases. But for a lot of the other attorneys who do work in this area, it certainly made it more difficult for them to bring these cases. There's legislation pending in the legislature that would fix that, that would just change what it means to win in the public records context. And then there's also legislation related to the WIAA, the Interscholastic Athletic Association, and whether they are subject to public records law. And I just want to touch on that very quickly. So the WIAA takes the position that they are not subject to the public records or the open meetings laws, and also that any public school officials who are also working in a WIAA capacity, typically as a volunteer on their boards or something, are also not subject to public records for anything they do there. Disagree with that take from them, but that is what they put out there as the law. There is a legislation now pending in the legislature which would make the WIA subject to the public records law, and that could impact some of your operations as schools in terms of what your employees can do. And related to that, I just want to mention very quickly at the end here that we were recently victorious in representing a student athlete who transferred and was denied a transfer waiver application. She wanted to play softball. She had never played high school sports before. She went to the WIA and said, hey, I'd like a waiver application. They denied her application. We told them that their denial didn't comply with their own rules. It actually violated the procedural rules that the WIA has. They ignored us. We then went to circuit court. We got an injunction against the WIA so she could play while it went forward. Ultimately, the WIA just this week backed down and granted her the ability to play. So just certainly something that I wanted to get on everyone's radar, something of interest. So.